Good morning, everyone. The court will take up first AG numbers 40 and 76, AGC versus Samuel Sperling and Jonathan Daniel Sperling. Mr. Brodsky. Is it Brodsky or Brodsky?
Brodsky. Thank you, Your Honor.
Okay, good morning.
Good morning, Your Honors. My name is Craig Brodsky. To my right is my co-counsel, Mr. George Mahaffey. We are from Goodell, DeVries, Leach & Dan in Baltimore. And behind us are our clients, Johnathan and Samuel Sperling. Your Honors, may it please the court, we are asking for the following. We are asking for Samuel Sperling to be sanctioned only with a reprimand. And we are asking that Johnathan Sperling's sanction be a continuation of his indefinite suspension with a right to reapply in 6 months. We believe that the facts and circumstances of this case, combined with this court's policy of protecting the public in disciplinary actions as the primary goal of disciplinary actions, to be the proper end result. We think that these sanctions are appropriate when we look at the conduct in this case, the lack of injury to their clients that they did, the mitigating factors as found by Judge Stringer, and the lack of aggregating factors as it relates to Samuel Sperling, and the small amount of aggregating factors as it relates to Jonathan Daniel Sperling. Neither Jonathan nor Sam took any client funds. Jonathan and Sam have the last name Sperling. That is their biggest problem in this case. Virtually all of the allegations charged against our clients were admitted early on in the process or refuted in Judge Stringer's opinions. Jonathan Sperling admitted immediately his checks that he wrote escrow checks to cash that he should not have done. Our clients admitted as early as January of 2014 that they failed to file the 5.3 employment agreement within 30 days as required by the rules. Our clients admitted from the very beginning that Leonard Sperling owned the Sperling Law Office's PC. And the findings of fact went through, and we looked at 69,000 files were procured in the computer forensic evidence. And there was one email in 69,000 files that constituted law-related activity according to Judge Stringer's findings. These findings by Judge Stringer were extensive. They were based on an assessment of credibility of the various witnesses, including our clients, Judge Lowenthal and Ms. Andrea Babist, and they were based on the testimony of the witnesses that he considered. And nearly all of them are not clearly erroneous because they came from facts that he cited in the record. And as this court is well aware, there's supposed to be significant deference to trial judge findings of fact, especially when they are based on the credibility of the witnesses. There were a host of other charges made by the Attorney Grievance Commission beyond those which we admitted from the very beginning, and nearly all of those were rejected. And they were closely evaluated. And the computer evidence is a very good story in this case to show you what was going on. One of the large issues at trial was whether Jonathan Sperling engaged in law-related activity. This tied into the charges by AGC that Jonathan indeed was their claim was he was essentially practicing as a lawyer, and their other claim was that Samuel Sperling was not appropriately supervising Jonathan. Judge Stringer, we turned the computers over to Bar Counsel. They were looked at extensively. There were 69 files accessed on the server. There were 69,000 files accessed on the workstation. 559 different files looked at on the server that had been accessed, and there was none of those, according to Judge Stringer's findings, with the exception of one email written in October, constituted law-related activity. So turning now to the facts of this case, I'd like to begin with Jonathan. As we discuss Jonathan Sperling's case, there was no finding that Jonathan Sperling breached his ethical responsibilities in the Jeter matter. There was no finding that Jonathan Sperling lied to clients. There was no finding and no charge that Jonathan Sperling took any client money. The most serious violations as it related to Johnathan were the checks that he wrote to cash and the judge's findings regarding the poor choice of the word several. The checks to cash were known to Bar Counsel all the way back in June of 2014. We acknowledge that the use of the word several was a poor choice of words.
Oh, by that you mean an understatement?
It was an understatement in terms of the numbers, that is true. But his petition for reinstatement in this court was denied right after Johnathan Sperling wrote to this court that he had written several checks to cash. So in some ways...
When you acknowledge it's an understatement, what are you acknowledging, if anything, about his intent?
Well, I think his intent was to be open to the court and to acknowledge that he indeed wrote those checks to cash, that he should not have done that. I don't think it was intended to deceive the court. It was more, he had counsel and that was the word choice that they chose. But I don't think it was meant to be an intentional, deceitful act, even though it was an understatement.
So you're saying that it was planned in advance to use those words?
Well, the record reflects that Johnathan Sperling had counsel at the time, who was Mr. Hesselbacher, and I'm sure the court's going to have some questions about the Pennington case and how we read it in terms of how it applies. So that was a decision that they made together, and the record did not reflect, in this case, why it was that they used the word several as opposed to it. But we acknowledge here today that it is a reasonable conclusion that several understated that amount, but at the same time, he was advising this court that he had indeed breached that responsibility, which was to not write checks to cash in violation of the escrow rules. And this court denied his petition for reinstatement. We don't know why, but we can presume that that was one of the bases for this court's opinions at that time. And that was nearly 5 years ago. And so he has been on suspension for nearly 5 years, in part because he did that and wrote those checks to cash. And so when we ask this court for a continuation of his indefinite suspension with the right to reapply for 6 months, we think that that necessarily includes the fact that he's been suspended for almost 5 years. In part, he was not allowed to be reinstated because of that particular violation of the rules when he wrote those checks to cash. And that takes me to my next point regarding Johnathan, is that in 2015, in January of 2015, within a few months of the temporary restraining order that was entered by Judge Cox, shutting down their father's law firm, we met with Mr. Grossman and Mr. Gaither, and this is the part that addresses whether or not we can have a settlement agreement with Bar Counsel. And this is one of the few areas that we believe that Judge Stringer erred. And we think it's Judge Stringer erred because we think we should be, counsel for respondents and attorneys should be able to reach a deal with the Attorney Grievance Commission. And we ask this court that the court can find that Bar Counsel can reach a plea and that that plea can be enforced and that that plea should have been enforced here. We followed the rule. We filed affidavits. We provided the factual basis, and all of the material facts relating to that agreement were met. Now, why is that important here? To us, one of the issues that we think is important is that this shows that the conduct that Johnathan Sperling engaged in, which was completed back in 2014, was all known to Bar Counsel. And Bar Counsel, Mr. Grossman, had been Bar Counsel. He had worked in that office for a long time. And his decision and his statement to us, and this is in the record, was that that he would agree to a joint petition for continuing Jonathan's indefinite suspension. And that was because what Mr. Grossman wanted was he wanted Johnathan to be away from Leonard. And if Johnathan was going to begin the roadmap to reinstatement What he should be doing is learning, relearning how to engage in the proper practice of law, which we did. We filed 4 exceptions as it relates to Johnathan Sperling. We filed an exception to Judge Stringer's finding that Johnathan did not show remorse. We filed an exception that we believe that the word several did not violate Rule 8.1. We also believe that Johnathan Sperling should not be penalized under Rule 8.1 regarding his login credentials because that was something that wasn't charged. We also believe that Rule 8.4 was not violated by the word several. And on page 8 of our brief, we talk about this. In June of 2014, Johnathan acknowledged his mistake and stated to this court that he regretted his mistake. On August 24th...
Now, which mistake are we referring to at this point?
For that, we're talking
The
about
several?
using the word several. And Johnathan testified at trial on August 24th on pages 121, 135, 137, 141 to 142, and 144 about his remorse, and he talked about how he assisted the receiver and why he assisted the receiver. And our position is that Judge Stringer's finding that Johnathan did not show remorse was not correct because one does not engage in those items and testify the way Johnathan did without feeling remorse. Our second salient point is that while Johnathan used inexact language, we simply disagree that several was a misrepresentation.
May I stop you before you move further in your argument? When it comes to whether or not Mr. Johnathan Sperling exhibited remorse, how much of this is really a determination to be made in the first and perhaps last instance by the hearing judge, as opposed to us on review, obviously in the first instance, but also, isn't it weighing it and determining the extent of credibility inherent in the representations by your client?
There is an element to that, Your Honor, and we do believe that Judge Stringer, by and large, did make findings based on the record. This is why we have limited exceptions to his factual findings.
And I appreciate that, but with regard to the sort of sense that the hearing judge in any given attorney grievance matter would have to make a determination as to remorse or not, there is, I think you are acknowledging, there is an element of sort of how much do I believe the protestations of respondent.
There would be an element to that, yes, Your Honor, but we think that...
So then to what, then is it a clearly erroneous review standard for us?
On that particular issue and that finding, I believe it is a clearly
Okay.
erroneous standard. And I would cite to those pages and those pages in our brief as evidence as to why we believe that that one limited finding from Judge Stringer was not appropriate. And taking that a step further, that brings us over to the 8.4C violation, which we believe that is, you specifically must have a finding of intent and that the use of imprecise language is just not an intent argument. And so for those reasons, we think that a number of the case law shows that an indefinite suspension would be the appropriate sanction for Johnathan. The Moore case has an indefinite suspension for misrepresentations that were not material. The Poverman case was a reciprocal case where there was one false, intentionally deceitful representation, a failure to cooperate, which we don't have here. The Burkhardt case was an indefinite suspension where the lawyer was making fake invoices for expenses to her firm, and it did not involve client. There were no client funds in this case. The McCullough case also was an indefinite suspension where the lawyers put unearned fees for personal uses in her operating account and did not refund her client and didn't respond to bar counsel's inquiry. And so these cases are all throughout the briefs, and we think that those cases would weigh against the disbarment for Johnathan Sperling. And so in summary, our position regarding Johnathan is he did not misappropriate any money. He did not profit from his conduct. He cooperated fully both with bar counsel and with Mr. Gillis, the receiver, and did not intentionally harm clients based on and there was no harm to clients based on the violations that were found. And so under current Maryland law, we believe that this does not warrant disbarment. Turning now to Samuel Sperling. Samuel Sperling was not charged with taking client funds. He did not make any misrepresentations. There was no intentionally wrongdoing found. There were no aggravating factors, and a significant amount of mitigating evidence. And so for those reasons, we believe that a reprimand is the appropriate sanction for Samuel Sperling. We see some of the key issues related to Samuel Sperling as found by Judge Stringer. Judge Stringer's findings as it relates to Samuel Sperling were largely, if not completely, supported by the records. They were not clearly erroneous, and we cite this at page 5. One of the big issues that Bar Counsel makes in their exceptions, Your Honor, is that they try to turn Samuel Sperling into the top of the Sperling Law Office. And other than having the last name Sperling, he was not a shareholder. He did not get a K-1. He didn't have blanket authority to bind the law firm. He wasn't an owner or operator under the tax return. And we said there are just a number of items in the record that do not put Sam Sperling above Leonard Sperling, despite Bar Counsel's contentions to the contrary.
I was a little
Please.
confused as to who was running the law firm. It seems like everybody took a step back or something.
Well, the testimony of record, as I think the best evidence of it, was from Andrea Babist, who Judge Stringer found to be credible. And Ms. Babist said the firm sort of ran itself. There were 3 experienced lawyers within that firm. Candidly, sitting here today, none of whom should have been practicing in a law firm owned by Leonard Sperling in violation of Rule 5.4. And we've acknowledged that Rule 5.4 agreement from the very beginning. And they sort of took on different and expanded roles based on who was doing what. Ms. Babist handled primarily the workers' compensation cases. Judge Lowenthal testified that she started to take over the district court matters and was more involved in civil litigation cases as time went on. And Sam Sperling continued to take over the bigger cases and handle those himself with assistance from the other people. I hope that I've answered your question.
So who controlled the money?
I think that's part of the problem in this case, is that Judge Stringer found that Samuel Sperling should have done more to control the dollars in the case.
And the Leonard and Johnathan were writing all these checks on the trust account.
Leonard and Johnathan did write those checks on the trust account.
How did they have access to the check?
How did they have access to the trust account checks? The system in the Sperling Law Office, according to the record at trial, was that they had a system in place where they kept binders and ledgers by a secretary's standpoint, and they did in fact write, and that's where the checks would be ledgered and client funds would be noted, and that's how the system that was in place was working.
Did they have a bookkeeper who was primarily responsible for maintaining these records?
The evidence at trial was that those were kept by a secretary's stand in the secretary pool area, and that whoever was logging in those information would write into the binder. Most of the handwriting in there was from a secretary, according to the record, because we highlighted in the record the entries that were there. And I'd like to point out, Your Honor, there's a significant issue in this case as to the impact of the Pennington case, and I think now is an appropriate time to talk about the Pennington case, because I believe our position is that Pennington doesn't completely bar Mr. Hesselbacker's involvement in this case and how it ties into the facts of this case. As I'm sure Your Honors are aware, Pennington was a case where Ms. Pennington hired a lawyer from Colorado to help her with her ethical issues. And the Colorado lawyer was not admitted to practice here in Maryland, and this court found that a lawyer should be familiar with his or her ethical obligations, and that you could not hide behind the fact that you hired counsel, especially in that case where the lawyer was not an ethics lawyer and was not admitted in Maryland, but was instead a Colorado lawyer. We read the Pennington case a little bit differently. And the reason that we read the Pennington case differently is we think the Pennington case doesn't stand for the gray area that says Samuel Sperling can't rely on his father and his brother to provide him with assurances that they're complying with the rules of professional conduct. He had a gray area of duty to supervise Johnathan. And knowing Johnathan had counsel was helping Samuel discharge that duty, and we think that that distinction is quite significant. As it relates to Samuel Sperling, the 8.4 violation is an 8.4a violation because of the other violations. The judge, based on credibility findings, found that Sam Sperling did not have managerial authority, that Johnathan was not engaged in law-related activity, and he went through a long list of why he was able to prove, why he did not believe that the misrepresentations were proved by bar counsel. We see the mitigating factors. Samuel Sperling had no prior record. There was an absence of dishonesty, timely good faith efforts to make restitution, and he cooperated with the AGC. And so when we look at the case law in this court, there is a number of cases that allow for a reprimand even when you have a 1.15 violation where the lawyer did not take the client funds. And we've cited those cases in our brief. And we think that the primary cases that, even one of the bar counsel cases, the Kwiatkowski case, had a 1.15 violation with the reprimand. But the Smith, the Zuckerman, and the Gracie cases had aggregating factors and people stealing client money, and therefore we think that those cases do not support a suspension against Samuel Sperling.
I misrecall what you are recommending with regard to Johnathan in terms of sanctions.
Our sanction for Johnathan would be a continuation of his indefinite suspension with the right to reapply in 6 months. And then I'd like to spend 5 seconds, if I can. I believe I have a few more moments before I save my last few minutes for rebuttal on the cost issue. And there were two primary issues with the costs that we think in this case. The first is the fees for Mr. Katzen. And we think it's wholly inappropriate for our clients to have to bear that expense in this case when all the findings from Mr. Katzen were essentially, the serious findings from Mr. Katzen were rejected by the trial judge. And so we think that that's the case. The second is that we were never told about Mr. Gillis's fees. He was a fact witness and was paid as if he was a treating physician, and we think that those costs should not be put on our clients. We do recognize that as restitution and as part of a sanction, if this court were to consider a reprimand for Samuel Sperling, that some cost shifting in exchange for and him having a reprimand would be something that might be a fair balancing point. Samuel Sperling has continued to pay 25% of any fees earned for any cases originated through the Sperling Law Office's PC to the Client Protection Fund as part of the restitution agreement with the receiver and the receivership. Thank you very much, Your Honor. I'm going to save the remainder of my time for rebuttal.
That's fine. Thank you. Ms. Lawless.
Good morning.
Good morning.
In Brennan, this court reminded the bar that lawyers are not suspended or disbarred capriciously and for less than compelling reasons, and that members of the Maryland Bar have their own duty under the rules of professional conduct not to assist suspended or disbarred lawyers from making a sham of the suspension or disbarment. Samuel Sperling made a sham of this court's suspension of Johnathan Sperling in July of 2013 and Leonard Sperling in October of 2013. The undisputed evidence is that Johnathan Sperling was indefinitely suspended on July 5th, 2013 for knowing and intentional misrepresentations. He showed up for work the very next day, making the exact same salary. On September 27th, 2013, Leonard Sperling was indefinitely suspended by this court for mismanagement of the trust account held by the firm. This court provided Leonard Sperling 30 days to wrap up his business until the effective date of that suspension. As of October 27, 2013, the effective date of Leonard's suspension, Samuel Sperling was the only licensed attorney with signatory authority on that trust account. Between the date of Johnathan's suspension in July and Leonard's suspension in October, Sam took no effort to ensure that Johnathan was limited access to either making deposits or disbursements from that trust account. Following Leonard's suspension in October of 2013, Samuel took no efforts to safeguard the client funds. As early as December of 2013, Samuel had actual notice that Leonard continued to make disbursements from that attorney trust account. The undisputed evidence is, and as stipulated by Samuel Sperling, in December of 2013, less than 2 months following Leonard's suspension, Leonard wrote a check from the trust account payable directly to Samuel Sperling. Samuel Sperling endorsed that check and deposited it in his own account. Notwithstanding these facts, Samuel took no action, and Judge Stringer specifically found that he was duty-bound and obligated under Rule 1.15 of the Rules of Professional Conduct to safekeep the funds in a trust account where he was the only licensed attorney. Not only did he fail to take any action once he had actual notice that Leonard continued to make disbursements, he failed to take any action after entering into a supervisory agreement with Johnathan to ensure that Johnathan ceased making disbursements from that account beginning in January of 2013. In April of 2014, Samuel was put on notice that Bar Counsel was specifically investigating him for the use and management of that trust account. Samuel did nothing. He did not confront Leonard. He did not close that account. He did not notify Bar Counsel of Leonard's continued use and disbursements from that account. He did not notify law enforcement that Leonard was misappropriating funds. He did not take any effort to safekeep the hundreds of thousands of dollars that were in that account.
Well, what I perhaps didn't quite interpret Mr. Brodsky's argument, but what I, as he presented it, but what I seemed to get was the gist of it, was that this was a firm that Samuel was not running, didn't need to be running because it was sort of running itself. It was like a rudderless ship, frankly, or a ship without a captain, and that he was merely an employee of the firm and not management.
Sure.
What do you say to that?
I think that there are two, that should be distinguished into two separate pieces. One of them deals with the trust account, because it is undisputed that Samuel was the only licensed attorney with signatory authority on that trust account.
So the other attorney's name, it escapes me.
Ms. Babbitt's and Ms. Lowenthal.
Uh-huh.
They were never...
They did not have...
Never. Johnathan, Leonard, and Samuel established that trust account when Leonard had been indefinitely suspended by this court for violations of the trust account rules in 2014. They remained the only attorneys with signatory authority on that account during the pendency and until the Circuit Court for Baltimore County entered a temporary restraining order on August 1st, 2014. And so I think one piece, Your Honor, is dealing with the trust account, and I think that the facts compel a conclusion that Samuel had an affirmative obligation, not only to safekeep those funds, but to keep both Leonard and Johnathan away from those funds. And under the Smith case, under the Zuckerman case, under the Gracie case, it is clear that where there is an affirmative obligation, he should be held accountable. I think the second piece is a little bit more complicated, and I think that that's where Judge Stringer made findings to which we have accepted, and that deals with the management of the operation of the firm. sort of who was running the firm, who was the leader of the firm. And the undisputed evidence from the witnesses, Ms. Babbitts and Ms. Lowenthal, that Judge Stringer credited, was that this was sort of a collaborative effort. Everyone just did the best that they could do. But in our exceptions, what we argued was that Sam had some sort of actual managerial authority over that firm, that he incorporated the firm in 2004 and was one of the original directors along with Johnathan Sperling, that no document was ever produced, no bylaws, no evidence that he was ever removed as a director other than his self-serving testimony at trial, that at all times Sam was the firm's resident agent, that he established the firm's trust account, that he was compensated by the PC by both way of a W-2 and a Schedule C, that following Leonard's suspension from the practice of law, he was the only attorney with signatory authority on the account, that he agreed to supervise Johnathan following Jonathan's suspension and was authorized to sign that supervisory contract on behalf of the firm, that once he finally confronted Leonard about his use of the trust account, that he affirmatively instructed Leonard, and this is in June of 2014, to cease and desist from making disbursements from the trust account. That following Leonard's suspension, Samuel instructed Leonard to consult with his attorney and follow the advice of counsel. And that in June of 2014, Samuel testified that he affirmatively took control over the firm. And so I think when you look at all of the facts and circumstances, that those all support that someone must be running this firm. It's contrary to public policy that Leonard could own and operate and run a law firm. And so maybe Ms. Babbitts and Ms. Lowenthal also had a modicum of responsibility for supervising or for running the firm, but that does not necessarily compel a conclusion that no one was running the firm. Maybe they were all running the firm. I really don't know. And so I think getting back to your question, Your Honor, when you look at the facts of this case, it necessarily follows that Sam had some sort of managerial authority in the firm, separate and apart from his affirmative obligation to safekeep the client funds.
Well, I assume, too, that, and you'll correct me if I have this wrong, that to a fair degree, the hearing judge can draw inferences from circumstantial evidence.
That's correct.
And part of your argument seems to be that that's what Judge Springer did here.
Yes. Yes, and I think that as distinguished from your question to Mr. Brodsky about is this clearly erroneous and asking us to reweigh the evidence, this is not asking to reweigh the credibility of someone's testimony. This is asking the court to look at the sum total of what was going on at that law firm following first Johnathan and then Leonard's suspension and dictating to members of the bar that they have affirmative obligations. Whether or not Samuel wanted to have managerial authority over that firm, when he stayed, he necessarily had it. He could have closed that trust account. He could have taken his clients and left the firm. He waited until June of 2014 to establish his own law firm, and still then, he didn't close the trust account. It wasn't until the Circuit Court in Baltimore County entered a temporary restraining order that the firm was finally shut down. And so while Mr. Brodsky says the purpose of attorney discipline is to protect the public, I think that this case is an opportunity for this court to send a directive to the bar as to what their affirmative obligations are when it comes to suspended and disbarred lawyers operating an attorney in law firms and continued law firms. And so I've cited, as it relates to Sam, I've cited primarily to the Smith case to support the recommendation that Sam should be disbarred. And in Smith, as the court will recall, this involved the theft from a trust account over a number of years by a solo practitioner's office manager or legal assistant. And what this court found was that Smith failed to fulfill his fiduciary obligation. He delegated tasks, that there was gross negligence, and that while perhaps his intent was not evil, it was not innocent. Similar to this case, Sam Sperling delegated the operation management of the trust account to Leonard Sperling while Leonard was suspended from the practice of law. He was grossly negligent in his failure both to safekeep funds and to create and maintain records associated with those funds. And while his intent may not have been evil, it certainly was not innocent. There was a severe injury that resulted from Samuel's failure to safekeep funds during the period of time between October 2013, when Leonard was suspended, and the entry of the temporary restraining order in August of 2014. Over $115,000 were misappropriated from that trust account. Unlike Smith, who made personal restitution to the victims of his assistant's crimes, Samuel has done nothing. He has let it fall to the Client Protection Fund, which has paid out hundreds of thousands of dollars due to Leonard's misappropriation. In Smith, this court found that there were three categories of misconduct: a failure to supervise, a failure to comply with the safekeeping rules, and misconduct of his assistant for which the respondent was responsible. Those three categories of misconduct, whether or not any of petitioner's exceptions are sustained, are present as they relate to Sam Sperling.
Would Samuel have known the total amount, $115,000?
Had he known?
Would he have been able to know that?
If he had looked at if he was not grossly negligent, Your Honor, those funds would not have been misappropriated because he would have closed that account. He would have immediately taken possession of the account. He would have taken Leonard off of the account. He would have closed, transferred the money, and otherwise kept those funds. So the $115,000 was a direct result of Sam's failure to safekeep those funds, that Leonard was continued to have unlimited access to this trust account, that he was allowed to continue to engage in the unauthorized practice of law, that he continued to settle cases following his suspension, that he was given unfettered access to the account to make both deposits of client and third-party funds and make disbursements of client and third-party funds.
But would Samuel have been able to know the total amount that was misappropriated simply from his access to the ledgers?
If he were to look at the bank accounts, Your Honor, and if he were to reconcile the accounts as he was required to do, he would have been able to know. I mean, that figure was readily apparent once the temporary restraining order was entered and Mr. Gillis was appointed as conservator, and there was an inventory done of the total amount misappropriated by Leonard. So had Samuel done what he was required to do, one, the funds wouldn't have been misappropriated because Leonard wouldn't have had access to that account, and had he kept appropriate records, he would have seen that there was ongoing misappropriation. And that was one of the distinctions that this court drew out in the Zuckerman case. And Zuckerman, again, was a case where it was I believe also a solo practitioner, and he hired a legal assistant and then essentially delegated entirely to her both the record-keeping aspects and the deposit and disbursement of funds from the attorney trust account. And in the Zuckerman case, it was a relatively brief period of time. If my recollection serves, it was only about 4 months between the time that the misappropriation by the assistant began and Mr. Zuckerman discovered the misappropriation. And it was discovered when he finally looked, or I think he got an anonymous call and then looked at the bank records and was able to determine. And what this court said in Zuckerman was he should have discovered it sooner. Had he been complying with his obligations to safekeep funds and appropriately reconcile accounts, he should have discovered it after month 1, because there is an affirmative duty to reconcile accounts every 30 days. And so I don't know if I'm circling around your question, Judge Watts, and I hope that I'm answering it, but the funds never should have been misappropriated. And had he been reconciling the accounts, had he been looking at the bank records, he would have been able to determine that Leonard continued to make disbursements both in cash and to himself from that attorney trust account. And I think what is so egregious about this case, and in many ways worse than Smith, is that Samuel was put on actual notice in the spring, in April of 2014, that Bar Counsel was investigating this particular trust account. He was asked to respond as to what changes had been made to the trust account following Leonard's suspension and to provide copies of the bank records. records. The evidence is undisputed that on May 30th, 2014, Samuel provided his response to Bar Counsel, and with that response, he provided copies of the bank records. And he would have this court believe that he didn't look at those records and that he didn't realize until the beginning of June that Leonard was continuing to make disbursements from that trust account. Samuel testified that he finally confronted Leonard in the first week of June of 2014 and told him, oh, stop writing checks from the trust account. That's all he did. He didn't close down the account. He didn't change the locks on the office. He didn't go to the bank and remove Leonard as a signatory on that account. He did not report Leonard to either law enforcement or Bar Counsel. He did not request a conservatorship. If he was truly not the owner of the firm and someone needed to take possession of the client files and the funds, Bar Counsel can do that. He did not go to the circuit court and request a temporary restraining order. He did nothing. And the evidence is clear that between the first week of June when he confronted Leonard, and the end of July when the TRO was filed, both Leonard and Johnathan continued to make disbursements from that attorney trust account. Samuel's misconduct is so flagrant in this case, and to have Mr. Brodsky stand here and say that he has accepted responsibility for what he has done is not borne out by the facts and the undisputed evidence. Samuel has never taken responsibility for his obligations imposed by the rules of professional conduct and imposed by this court to safekeep client funds. The loss was huge. And so, as to Samuel, regardless as to whether or not the exceptions are sustained, petitioner recommends that this court disbar Samuel, send a message to the bar that this type of gross negligence, conscious indifference will not be accepted by members of our bar.
Did I understand you to say regardless of how we will dispose of the respective sides' exceptions?
That's correct.
Well, really, you don't have exceptions, response to your exceptions.
That's
of course.
correct. You're right.
Okay.
And I think that the majority of petitioner's exceptions as they relate to Samuel, as they relate to Rule 5.3, 5.4, and 5.5, are sort of subsumed by the general safekeeping rule violation. And so they're nuanced points, they're sort of policy points. I encourage the court to reach them to send directive both to my office, but also to the bar as to the specific points of law, given this particular fact pattern. I did the legislative research such as I could to look at the rules order and how it came into being as to Rule 5.3D. I know that there was specifically comments made during the Rules Committee as to specifically prohibit suspended or disbarred attorneys from being retained in family law firms, and that was rejected. And then, as I cited for this bar, then Chief Judge Bell, Judge Green, and Judge Raker, in declining to adopt Rule 5.3D, said the other rules as they exist, specifically 5.4 and 5.1, cover this proposed course of conduct and that it's unnecessary. I urge this court not only to find that it is necessary, but that someone must be responsible where there is a suspended or disbarred attorney that continues to practice law.
Is there evidence in the record about who controlled the operating account?
The evidence was that Leonard continued to control the operating account.
Up to the time of the TRO?
That's my understanding. That's my understanding. And
Ms. Lawless, one of the things offered by Mr. Brodsky is mitigating as a payment to the Client Protection Fund of 25% of profits from the current firm. Are you aware of that?
I think if that's what was said, that was not what was meant to be said, because that's not true. What happened was after Mr. Gillis was appointed receiver by the circuit court, he had two tasks. Essentially, one task was to deal with open and active client matters to assure that they got their file returned and successor counsel came in to represent them. The second task was to determine the amount of loss due to Leonard's misappropriation to assist those clients in getting the records and documents they needed, and those clients filed claims to the Client Protection Fund. There were a number of the active open clients that chose Sam as their successor counsel. And so the 25% that Samuel paid was a fee split between the receivership on the one hand and Sam on the other hand. And so that was to cover the receivership's, I guess, the cost of getting those files together, getting them in order, and transferring them to Sam. So the 25% is a fee split. It's not restitution payments to the Client Protection Fund. As to Johnathan Sperling, Johnathan Sperling was indefinitely suspended by this court for a repeated pattern of misrepresentations and dishonesty. His misconduct began almost immediately after his suspension on July 5th, 2013, and continued through the entry of the temporary restraining order in August of 2014 and the numerous misrepresentations to bar counsel in this court in an effort to obtain reinstatement to the bar. The cases cited by Johnathan, Poverman, Moore, Burkhart, McCullough, and Calhoun are all easily distinguished from this case. Those cases were all indefinite suspension with some right to reapply, and the respondent attorney in each of those cases had no prior discipline. The Reinhardt case cited by Mr. Brodsky was a 4-3 decision in which Mr. Reinhardt received an indefinite suspension from the practice of law where he had previously been indefinitely suspended. His prior suspension was many years in the past. In that case involved one client, one case, there was no misappropriation, and there was no criminal conduct. I would urge this court to distinguish all the cases cited by Mr. Brodsky and disbar Johnathan Sperling from the practice of law. Thank you.
All right, thank you. Mr. Brodsky, I realize that, of course, you did file a number of exceptions. I'm thinking ahead to another matter.
That's okay. We did not really file a lot of exceptions to the facts as it relates to Samuel Sperling, but more the import of what those factual findings were.
Understood.
And to that point, I'd like to begin with this assertion that Sam Sperling could have closed the escrow account. I think this is a core legal dispute, and we simply disagree with Ms. Lawless on this point. And we've cited some cases and some rulings from the FTC that says that and these were exhibits to our response to the petitioner's exceptions. And what our position is, Your Honor, is that just because you are a signatory on an account does not give you the right to take over the account. The owner of the account is the trustee, not a signatory. Being a signatory gives you the right to cash checks, it gives you the right to write checks, but it doesn't give you ownership and control over the account. So the assertion that that Samuel Sperling could have closed the account and taken over the account, in our view, is just simply not supported by the law.
Do you agree that he had an obligation to keep the funds in the account?
If they came into only those funds, I think 1.15 says that the funds have to be in the possession of the lawyer. So I don't believe that Ms. Lawless met her burden that all of those funds came into the possession of the lawyer. I don't think she argued that in her, I don't think that was presented at trial with respect to each particular case. She did ask what cases Samuel Sperling worked on, but she didn't prove when those cases were settled, when those checks came in, and when those funds should have been dispersed. And in response to something, I don't believe the amount that was not present in the escrow account was easily determined by the ledger. That was a significant undertaking by the receivership that my clients actually assisted with. And to your point, Judge, related to the 25%, here's the 25%. Those cases were originated by the Sperling Law Office, PC. We reached an agreement with the receiver that the cases that belong to the Sperling Law Office would be split. The clients could choose where to go. We worked with the receiver. We sent letters. Some chose Mr. Sperling. Some chose Andrea Babbis. Some had the right for additional lawyers. The clients then advised Mr. Gillis who they wanted. There was then an agreement reached among everybody that the fee split for work done, work originated, et cetera, would be 75-25. The next piece, though, was that the only claimant to those funds that were collected, there were two claimants. Number one was Mr. Gillis's fees, and number two, everything else went to the Client Protection Fund. And to this day, Sam Sperling continues to send 25% of any TLSO originated cases to the Sperling Law, to the Client Protection Fund, to the extent that that was there. In addition, Sam Sperling testified at trial, as did Ed Gillis, that he reduced his fee on some cases where the client lost money because of Leonard Sperling's actions. And so there is evidence of restitution, and with regard to, in our view, we think the 25% is keeping up with his cooperation and repaying the Client Protection Fund as he agreed to do, and also as it relates to him reducing his fees, which is in the record.
And so do you consider those actions an admission of wrongdoing, or Ms. Lawless is urging this court that there's been no admission of wrongdoing on this behalf?
I don't know that I like the word admission, Your Honor, but I do consider them evidence of cooperation and mitigation, and recognizing that Sam Sperling could have done more looking back in hindsight. And as he testified at trial, he wished he walked out the door long before the evidence ever got to this point. And that's what he testified to at trial.
Counsel,
Yes, sir.
whose responsibility was it to manage the trust account?
I think at the end of the day, it was all lawyers who came into possession of client funds. And so there was some element of responsibility with regard to Sam Sperling that probably should have been done differently looking back in hindsight. But we see that violation in this case as the same problem that we have on the 5.4 issue, which is that Sam Sperling was working in a firm that was owned by a non-lawyer. And as a result, we think in this case, the appropriate sanction is still the same. It's still the same conduct, and this is a gray area of the law. So if I could wrap up very quickly in 20 seconds, Your Honor.
I just wanted to answer my question. I don't understand. Did Sam have any responsibility for money that was already in the escrow or trust account?
I don't think so, Your Honor. I think he only had responsibility for those funds that he came into possession with and for those cases that he worked on. But other clients, I don't think so, because he's not the possessor of those funds.
Which rule are you referring to when you say that?
I believe the beginning of 1.15, Your Honor, provides that when a lawyer comes into possession of funds belonging to a client or someone else, I don't think I phrased it exactly perfectly.
I see it.
But if I could end on one sentence, Your Honor, we think that this is a gray area of the law. And so unlike Ms. Lawless, who wants to make an example of our clients, we would ask this court to look at the policy and the cases that talk about how we don't sanction lawyers so severely when we have gray areas of the law. And those cases are in our brief. Thank you very
good.
much.
Thank you. Thank you, counsel, for both sides. Next is number